This documentary video is made in the public interest. Most taxpayers do not know that there is no statutory law or no legal mechanism to bring a Chief Constable or Police and Crime Commissioner to account for institutionalised police misconduct. The Police Reform and Social Responsibilities Act 2011 was introduced so that police and crime commissioners would hold the Chief Constable in the forces area to account for the conduct and the policing of that force. To quote from the 2011 Act, police and crime commissioners have been elected by the public to hold the Chief Constable and the force to account, effectively making the police answerable to the communities they served. However, there is no statutory law that the IPCC can invoke to hold a Chief Constable to account for criminal allegations of misconduct in public office, nor is there any statutory law that the IPCC can invoke to hold a police and crime commissioner to account for his failure to bring a Chief Constable and the subordinate officers into line for misconduct in public office. The taxpayers spend millions of pounds a year on the IPCC, the Independent Police Complaints Commission. There are commissioners all over the country on six-figure salaries along with their support staff, and really most people who use the services are dissatisfied with the results. It would appear that if a person has gone up the escalation procedure where they are dissatisfied with the way misconduct allegations have been handled by the Professional Standards Department, they've appealed these to the IPCC, and they have then complained to the Chief Constable about their subordinate officers and the lack of integrity and misconduct. There is no legal mechanism at all to bring a Chief Constable to account. The legal mechanism in statute law is to complain to the Police and Crime Commissioner, but the Police and Crime Commissioner is often sitting cushy with the Chief Constable and the officers around them, and therefore they do not have the will to hold the Chief Constable to account for institutionalised police misconduct or direct police misconduct of the Chief Constable. A private prosecution appears to be the only mechanism available. The police for years have relied on forcing criminal allegations of misconduct against their officers into civil litigation, where the police will employ barristers to perjure themselves and lie in court to justify or try to lose the misconduct allegations in civil litigation. But even if the victim is successful in civil litigation, it is the taxpayers ultimately that will pick up the tab for the police misconduct with compensational fees. The actual criminal side of the misconduct in public office, the officers are never ever held to account for these criminal offences. In the case that we are exampling here, there is an auditable, documented trail showing a course of conduct that amounts to misconduct in public office. This is a indictable common law criminal offence. The definitive case on misconduct in public office is the House of Lords case Regina versus Ditham, where it was contended and argued the difference between misfeasance, malfeasance and non-feasance. Basically, a course of conduct that amounts to misconduct where an officer either fails to perform a duty incumbent upon him, or lies, prevarication, and other forms of a course of conduct amounting to misconduct, would come under the common law criminal offence of misconduct in public office. It is well established in British law. The Dytham case was a 1970s case. Prior to that, the definitive case was Regina versus Wyatt. Wyatt was a 1700s case predating the police force, where a village warden was ordered to levy a fine by a magistrate, which happened to be on a person he knew. He failed to do it. It was a course of conduct amounting to misconduct, and Wyatt was deported to Australia as a result of it. So misconduct in public office is a well-established common law criminal offence where there is no statutory law to invoke. I quote from the Crown Prosecution website: "The use of the common law offence should therefore be limited to the following situations: where there is no relevant statutory offence, but the behaviour or the circumstances are such that they should nevertheless be treated as criminal." In other words, a course of conduct that amounts to misconduct should be treated as criminal and not civil matter. As a result of a catalogue of police misconduct, the victim of this case finally made a criminal allegation against the Chief Constable to the Police and Crime Commissioner in compliance with the existing statute law. The Office of the Police and Crime Commissioner refused to record a complaint against the Chief Constable for reasons best known to themselves. As a result of that, the victim appealed this to the IPCC, who upheld the appeal and instructed the Police and Crime Commissioner of Dorset to record a complaint against Debbie Simpson, the Chief Constable of Dorset. Therefore, the IPCC have now exhausted their statutory powers. They have no power at all to invoke, to force the Police and Crime Commissioner to have the Chief Constable investigated by an outside force or some other prosecuting authority. The prima facie case against the Dorset Police and Crime Commissioner for misconduct in public office has been served in the St Albans Magistrates Court. The reason for this is that Hertfordshire is a neutral county, completely separate from Dorset Police and the Dorset Magistracy. There is a scrutiny panel that supposedly scrutinise the Dorset Police and Crime Commissioner. This is made up of councillors and others. In this case, it's not appropriate to make criminal allegations of misconduct in public office to a scrutiny panel, because all they do is scrutinise. They are not an investigative authority that can deal with criminal allegations against the Police and Crime Commissioner and the Chief Constable. Therefore, we are back to the only feasible way forward, which is a private criminal prosecution of misconduct in public office.